Hello, everyone. My name is Ariella Wagner. I am the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights through our extraordinary online system. Today, we have a fabulous webinar conducted by Jordan Rappaport, who is a partner at Rappaport Osborne Rappaport. He has been representing debtors, creditors, and businesses for over 24 years. And today's topic is Bankruptcy Happens. How do I get paid? So without further ado, I would like to introduce the wonderful Jordan Rappaport.
Good morning, and thank you for that wonderful introduction, Ariella. This morning, we're going to be talking about how to get paid in bankruptcy. And the first thing that we need to address is that bankruptcy is a lot of times not a choice. When a bankruptcy is filed and you get notice of it, you are in it. It's federally mandated that anyone who is part of a bankruptcy action has to obey the automatic stay. What does that mean in English? That means that when a project or a homeowner or a business files bankruptcy, all of its assets and all its creditors are contained within the bankruptcy case, and all actions, especially collection actions, are stopped in their tracks. Even if somebody or company filed bankruptcy and wants to pay you after they file, legally they cannot. Whether you like it or not, you are involved. The instant you are aware of a bankruptcy, you need to carefully and constructively look at what you're doing, how you're doing it, and consult a professional who is experienced with bankruptcy matters. Because if you do not obey the rules of bankruptcy, whether or not you are aware of them, you could find yourself in hot water. More importantly, if you do understand how things work or can get advice on how things work, it's easier for you to get paid, because that's what the goal is, for you to be paid for the money that's owed you. So let's talk. What does that mean? What does it mean when you're owed money from a company that's in bankruptcy? The best example I can give is that recently I was involved in a case involving a real estate developer who was developing between 15 and 25 properties in the South Florida area. They became overextended. Their lenders were threatening to foreclose and were on the verge of foreclosing and taking back the properties. And this real estate developer chose to file a bankruptcy proceeding to stop the foreclosures and hopefully reorganize their business. At the same time, all of the material suppliers, the contractors, subcontractors who are working on these properties were all then intertwined in the bankruptcy, whether they liked it or not. I've represented various creditors in bankruptcies just such as these, and it's important to understand what you can and can't do, and more importantly, whether you should even continue doing business with those an entity or a business that's in bankruptcies. There's pros and cons. We're going to go over some of them right now. Most importantly, if you are doing business, you are supplying materials with on a project, you need to make sure that when legally available, you file those liens. That's one of the services that SunRay Construction Solutions does. When those liens are filed, if you are entitled to file those liens, do it as soon as possible. The reason being, aside from the obvious, is that if a bankruptcy is filed, it will put you in a better position. What does that mean? When you're dealing with bankruptcy, there's two types of debts. There's contractual debt and loan money. And more importantly, there's secured and unsecured. It's always better to be secured. That means that when you provide materials or do work on a particular project and you file that lien, it puts you in front of the general unsecured creditors. That means that you take a priority position, and if and when the property is sold, you will be paid first. It's better to be first in line than last in line when it's time to get paid. So let's talk about those two types of debts. The contractual debt, a contractor who does work or sold supplies. You install windows and doors. You supply concrete. I represented a concrete supplier on a bridge job one time. The bridge actually ended up falling and there was a lot of lawsuits. Ultimately, that that concrete provider chose not to file a lien, and therefore they did not get paid as much as some of the suppliers who did file liens. Once again, and I'm going to repeat myself, filing liens is of the utmost importance. Whether you're able to file a lien, whether you're licensed, whether Florida law allows it, those are issues that we're not going to go into here. But to the extent that you have a professional or a company such as Sunray who is going to assist you with those filing of the liens, you need to do so as soon as possible. In some other cases, maybe you're a hard money lender. Maybe you've loaned money on a piece of property. You need to record those mortgages and don't bend over backwards for the people you're loaning money to. I was involved in another case where somebody took out a $250,000 mortgage on a piece of property with equity in it. The homeowner decided or convinced the lender not to record the mortgage because they were trying to keep their credit at a certain level. And in the few months after taking out the loan, they borrowed money from another party, thus putting them in front of my client. So my client, who did not exercise his legal right to record that mortgage immediately upon dispersing funds, ended up third in line instead of second in line, and that was definitely a large mistake. Bankruptcy, when it is filed, differentiates between those secured and unsecured debts, and in some cases, it actually can provide you with what's called an administrative priority. So here, looking at slide 2, it says if ongoing may be entitled to administrative expense. What does that mean? Well, in some cases, the bankruptcy that's filed is what's called a Chapter 11. That's a reorganization. That means the business is still operating. It's not shut down. They may need you to continue to supply materials. They may need you to continue to fix up the property, do repairs on a property. There may be ongoing projects where you're either a contractor or subcontractor. If in fact you're going to continue to do those post-petition, post-filing jobs, it is imperative that you communicate with the attorneys for the bankruptcy company so that you can continue to get paid. There's a large distinction in many cases between pre and post-petition, and it would be a shame if you were to continue to do work day after day after the case is filed and not make arrangements to get paid. I've seen that happen too. Now, what happens if you filed your lien, you're no longer doing work, you're waiting to get paid, and the bankruptcy is filed? You need to pay attention to what is going on, because that piece of property or that project, which you may have a valid lien on, may be disposed of within the bankruptcy proceeding. There is a method within bankruptcy called a Code 363 sale, wherein a property can be sold free and clear of liens, and if you're the last lien on the property and there's not enough equity to reach you, you may find yourself going from a lien holder to simply another unsecured claimant who may get pennies on the dollar. You may be able to object to the sale of that property within the bankruptcy. You may be able to have a voice in that case. It is important that you pay attention to that, and to the extent that you need to, hire a professional, whether it's myself or someone else, to explain to you what's going on, and if in fact there is the ability, maybe hold up that sale so that you can get paid, if not all, maybe a portion of it. Now, if your lien is valid and there's equity in a property, once those assets are sold, you can be paid. You can be paid at closing. But if there's no equity, you may find yourself having to deal with what's called a plan of reorganization in a Chapter 11, or in a Chapter 7 case, you may just get pennies or maybe even nothing. It depends upon how much money is brought into the bankruptcy estate. These are things which you need to review and go over once you find out about the bankruptcy. And I know I'm repeating myself, but it's of the utmost importance that once you're aware of the bankruptcy, you don't sit in your hands. Here's a perfect example. Right now, I'm representing a hard money lender who loaned money on two refurbished home projects. He has a first mortgage on two pieces of property. The property owner just filed a what's called the Chapter 13, a Chapter 13 proceeding, wherein they're trying to strip off the mortgages. Well, what does that mean? They're saying that the properties are of so little value that the money loaned on it is partially secured and partially unsecured. So let's talk about this with real numbers. Let's assume that you're either a lien holder standing behind a mortgage on a piece of property, or heck, you loaned, I don't know, $500,000 on a home that's being refurbished. Well, what if the homeowner files bankruptcy and says this is an investment property and the property is only worth $250,000? Well, they could file a motion within a bankruptcy, which would change your position from holding a mortgage of $500,000 to holding a mortgage of $250,000, and classify your other $250,000 as unsecured. So you went from day one having a mortgage for $500,000 to day two having a mortgage for $250,000. You need to pay attention to that. This happens very fast, and some attorneys who do this sort of thing can call it sneaky, if you will, but they will go through bankruptcy and things will happen fast. And if you get notice of this and you sit on your hands and don't just wait for things to happen, you may find yourself on the short end of the stick. You need to be aware of that and pay attention, because the bankruptcy court has very powerful equitable powers, which can change your lien rights, and in some extreme cases, even change your mortgage rights. Now, let's talk again about secured debt and lien rights. In all reorganizations, especially Chapter 11s, they're required to file a plan and disclosure. That's the goal of a Chapter 11. This plan and disclosure will list down how you are to be paid, if you are to be paid, and when you are to be paid. You may have voting rights. You may have a large say as to whether or not this bankrupt company or bankrupt project is able to go through bankruptcy easily, or you can make it difficult for them. You need to pay attention as to what they're trying to do and be aware of it and how it affects you. There is a process and pattern in every Chapter 11 proceeding, and it can be filed along by an attorney. It can be filed along by you with advice from your attorney. You can look at the plan that was filed, and you can see how you're being treated. If you do not like how you are being treated, you can object to it. You can go to a judge. You need to enforce your rights. You need to be aware of what's going on. And these could be either very big cases or very small cases. I once represented a guy who worked on driveways. He supplied bricks for various driveways, and in one case he filed a lien because he supplied $3,000 or $4,000 worth of bricks, and another project he did not file a lien. Both homeowners, ironically enough, filed bankruptcy within a month of each other. The one where he did not file a lien, he ended up getting like 2 cents in a dollar. The one where he filed a lien, he ended up getting paid in full plus interest over a period of 3 years. Now, mind you, I'd rather have all my money up front, but if not, if I get paid in full plus interest over 3 years, at least I'm getting paid. It's important to pay attention. There's a couple different types of bankruptcies, 7s, 11s, and 13s, and while we're not going to go over the distinctions between those during this short webinar, it's important to understand that different bankruptcies treat your lien and treat the money owed to you differently. And once you're aware of those differences, and once a professional and such as myself explains them to you, you can then act accordingly on the debts that are owed you. So let's summarize, because it's not rocket science if you actually pay attention to what's going on. You don't have to know anything about bankruptcy to understand you're affected by bankruptcy. I don't understand how the engine of my car works, but I understand it's important. And if it breaks down, I go see somebody who can help me with it. When a project goes belly up and files bankruptcy, when somebody you're doing business with files bankruptcy, you need to pay attention to it, because as I said, whether you like it or not, even if you try to ignore it, you're affected by it. And I'd hate to leave money on the table. I'd hate for you to not enforce those rights. Most bankruptcy attorneys will sit down, talk with you. I guess nowadays it's more of a virtual thing, be it Zoom or by phone, but they can tell you probably pretty fast whether or not it even makes sense to hire an attorney or not. For the more complex cases and for the larger debts, hiring an attorney can help you recoup some, and in some cases, maybe all the money that you're owed. Especially when projects get sold and you have customized either windows or doors or other materials that were specifically ordered for specific properties. Remember, if you have specialized or specific, for instance, windows, doors, roofing, tiles for a specific project, they may be worth only something to that property owner and not merely that much on the open market. These are things you have to think about and look into when you get notice of this. There's an old saying that an ounce of prevention is worth a pound of effort. The lien rights that you have, the ones that you can file and file accurately through Sunray Construction Solutions, will at least provide you with some protection if in fact bankruptcy happens. And bankruptcy will happen more and more as the economy continues to recover. Businesses overextend themselves. Lenders are not going to be patient as we go forward. I'm seeing an uptick in construction bankruptcies, as construction continues to increase, as builders continue to expand, as people continue to refurbish their homes and do other projects in their home. The small business owner, such as yourself, the one who fixes roofs, the one who supplies, fixes up pools or adds improvements to a home, you need to be careful of this trap. And when it's sprung, speak with the appropriate professional. That really is the extent of my notes for today. If anyone has questions, I'm happy to answer them. My information was sent out with the webinar information. If anyone needs to contact me, my firm name is Rappaport Osborne Rappaport. You can find me easily at www.rorlawfirm.com. My email address is Jordan, Jordan, at rorlawfirm.com. I'm happy to speak with anyone, return an email, question, and help anyone who finds himself having to deal with bankruptcy, especially if you have a lien, because it is a lifeline.
Thank you so much, Jordan. And at the end, in another maximum 5 minutes, we will have another screen where if you did miss his contact details, you'll see his phone number and his email address. For those who are current customers and customers that would like to know a little bit more about the Sunray System, it's pretty extraordinary. Just a few notes. We'll run through these slides quickly so that if you do have a question, we can answer them for you. So Sunray has waivers and releases for free. If you use our system, you do not have to fill out a Word document or a PDF. All of the information is there for you to just click on, and within a matter of 60 seconds or less, you can create your partials, your finals, conditionals for your releases of liens, as well as store them so that if you have to go back to see your partials, you can see them all online. Would you please go to the next slide? For our other larger customers that do at least 50 notices a month, we have an incredible system, an API, which is basically a bridge. It's a bridge from your system to our system, eliminates data entry. It's very user-friendly, but we would need to have an IT support from your side on your company. If we can go to the next slide. If you do not have an IT department, that can help you. And sometimes IT prioritizes what they need to work on next. We also have an incredible Excel spreadsheet where if you have the ability to export the data, like your first day on the job, your job address, you could just export it and poof, put it into our system. It's much easier. Thank you. And then the last, one of the other slides, tracking. You could track all of your certified mail online. Very simple, very user-friendly. You could see if it's been accepted, if it's been delivered, the signatures, and if we can go to the next slide. And we now have a wonderful service where we can assist you in e-recording your documents. So some states require a notice of commencement, notice of terminations. We can assist you with e-recording in most counties. And the final slide. Yep, and Sunray, of course, helps thousands of customers secure their lien and bond claim rights. We secure over $10 billion annually. And that is it for the presentation. So the last slide, which is really the most important slide, is our contact details. Jordan is really fabulous about getting back. If there's a specific question you have, here is his email. On the right-hand side of your GoToWebinar screen, you can ask a question. Please do not give the specifics of company names if you do have a question, and we'll wait just a moment in case someone has a specific question that wasn't answered. Because obviously you all signed up for a webinar, and there may be a question you have that you would like to ask. And don't worry, we are the only ones who could see it. So feel free to ask your questions. You know what, Jordan? It looks like you did such a sensational job at the moment, but you may receive, or I may receive an email later. And if we want to go to our last screen, I want to say thank you to everyone for attending our webinar. I hope you have, Jordan, by the way, great job. Thank you very much. And to the attendees, I wish you a sunny day.